Hey, Ramos, do you hear me?
Yes, I can hear you, Honorable Kasa.
Oh, it's Monday.
Oh, sorry, Honorable Zumand, my apology.
Oi, oi.
Oh, you
Sure.
are audible, Honorable Zumand.
Oh, sharp, sharp.
Thank you, Honorable Zumand.
Good morning, honorable members, provincial delegation from portfolio committees, the officials from COGTA, Public Service and Administration, as well as our support team in the NCOP. I would like to take this opportunity to declare this meeting open. It's now 10 o'clock exactly on my watch. Today we are processing the provincial mandates on the Independent Municipal Demarcation Authority Bill, Public Service Amendment Bill, Public Administration Management Amendment Bill. So we'll afford the departments to table those provincial mandates, and as well as our legal team from the NCOP to make their own presentation. Then we engage, and we'll also have the tabling of such mandates to the NCOP. We'll work with the programming and the chairperson of the NCOP and the chair of chairs to ascertain that a slot is secured, and the chief whip, so that we can present what will be constituting our report in relation to processing of these Section 76 bills. Without any further ado, I'll request that we allow members to introduce themselves within a few minutes. Then from there, we'll proceed. Honorable members, we can start with our whip of the committee, Honorable Molokome.
Oh, thank you, Chairperson, and good morning to honorable members and to us on the platform. My name is Regina Molokome. I'm a permanent delegate from Limpopo Province. I'm also the whip of this committee. Thank you, Chair.
Thank you very much. You can follow Honorable Taiza. I saw you on the screen.
Thank you very much, Chair. My name is Kanyata. I'm a permanent delegate from Mpumalanga Province.
Next member.
Good morning, Chair. Good morning, colleagues and administration. My name is Rikus Baardnors, Permanent Delegate, Western Cape.
Thank
Good
you.
morning, Chair.
Yes.
Morning, Chairperson, and morning, everyone. My name is Jabulani Nzimande, a permanent delegate from Gauteng.
Thank you very much. Honorable Peter, you can come in.
Good morning, Chair. My name is Mandla Peter, permanent delegate from Eastern Cape. Thank you, Chair.
Thank you very much. Dr. Skirkok.
Good morning, Chair. Igor Skierkogel, permanent delegate. Oh, I'll change my background now. Sorry. Permanent delegate.
We're going to charge you.
Permanent delegate from the Free State. I'll change my background now. Sorry. From caucus meeting. Sorry, Chair.
We're going to fine you 500 rand. Thank you. Honorable Mabibo. Hoshi Mabibo. Welcome back.
Good morning, Chairperson. My name is Khosana Solima Bebo from Bokonibu Pirima. I'm representing Northwest in the North NCOP as a permanent delegate of this committee. Thank you very much.
Thank you very much, Honorable Mabibo. We hope that you are making a good progress in your recovery. We wish you a speedy recovery. Let's move to Honorable Briat.
Chairperson.
Honorable Makesini. All right. Those are members who are present. Thank you very much. We'll then request that we proceed to the apologies.
Honorable Chair.
Wait, madam. I'm gonna be fired here. Hey, I'm leaving my chief whip outside of these introductions. My apologies, chief whip.
Thank you, Chair.
Over to you, chief whip.
Kenny Mwima. Kenny Muimang from Northern Cape. Thank you.
The vast province.
Thank you. Thank you.
Thank you
Chair.
very much. Let's then move. Any other member? Okay, let's move to apologies. Let's take apologies. Mr. Manele.
Thank you very much, Chairperson. Chair, the only apology, Honorable Breed will be running late. She will be joining the meeting around 10:30. Thank you very much, Chairperson.
Thank you. What is happening with Honorable Makesini and Honorable Ceza? Okay, let's proceed. Can we move to the adoption of the agenda that is tabled before us? Members, can I get a mover?
I move, Chair.
Honorable Peter moved. Any
Chairperson.
seconder?
Chairperson,
Yes.
Honorable
Whip?
Molokome.
Yes.
Yes, I just want
Thank you.
on the program, Chair, I just want to check if all the departments are present in this meeting, because if you can remember, Chair, in our plan that we have adopted, the program itself, it has the indication was the departments were supposed to come and present, I think by next week, if I'm not mistaken. So I just want to check if all the departments are here and are ready to present. I know in terms of the mandates, the provinces, you'll find that they have sent, like my own province, I have the mandates on the two bills, the Public Service Amendment Bill and also the Public Administration Management Amendment Bill. But I just want to check in terms of the demarcation one, if the department is ready to come and present. If not, Chair, if we can deal with the two items, item 1.2, 1.3, and check if the other department is ready for the demarcation one. Thanks.
Okay, let's check.
Before I can second the adoption of the agenda.
Okay, no, that is procedural. You are correct, Chief Whip. Let's then double check the delegations, because there are standard apologies. Whenever we meet on Wednesdays, we are aware that the cabinet is also sitting today. So the ministers are not going to be able to make it, and the deputy ministers, because they sit in these cabinet committees and cabinet. But let's check the first bill, which is Independent Municipal Demarcation Authority Bill. Do we have representatives from Cooperative and Demarcation Board? Yes.
Chair, just to provide an update based on what the whip has raised, when previously the committee program that was sent to the department, the legislative program, was saying today we'll be dealing with the tabling of negotiating mandate. And the week which is on the 16th, the department and our Parliamentary Legal Service will be responding to our negotiating mandates. Based on our discussion, myself and you, Chair, last week, we took a combination approach to say we'll allow today the tabling of negotiating mandate and departmental responses to negotiating mandate. Administratively, we made an assessment of the readiness of Parliamentary Legal Service and the department. Fortunately, Chair, the Department of Public Service and Administration at first had a problem with that, but finally she agreed and said, "Moss, it means I'll have to work over the weekend." Both Legal Service and the Department of Public Service and Administration, they responded and say we'll be able to respond to negotiating mandate. The assessment with regard to the Parliamentary Legal Service and Department of Cooperative is that the Municipal Demarcation Authority Bill had serious legislative and constitutional matters. And in terms of the short notice to say today they must respond, they will be unable to. An appeal was made that we must stick to our original program, which includes their response to be tabled next week on the 16th, or once the committee has decided on an appropriate date. Thank you very much, Chairperson.
So the first one falls off. Is that what you're saying?
Correct, Chairperson.
Okay. Honorable Whip, you can proceed.
No, thank you, Chairperson. With that explanation, it means 1.1, it will fall off. Then we continue with the other items on the agenda. Then I second the move, Chair, with amendments.
Thank you very much. The agenda is duly adopted with those few amendments and the deferment of the first item to the next meeting. With that being said, members, let me take this opportunity as well to wish all of us good deliberations in this meeting, but also acknowledging the heavy rains which visited few provinces last week, which caused some damages in properties. We wish to keep those families which were displaced in our prayers. Also thanking those members, including our Chief Whip, who led the delegation to the funeral of our honorable member, Honorable Brain. And we hope that God will continue to comfort her family during this trying time. And we proceed looking forward to the achievements and attainment by Bafana Bafana. Yesterday, they played 1-1 with Nigeria, which is a positive result, and we wish them all the best to qualify for FIFA World Cup next year. With that being said, let's then proceed to the next item. Honourable members will allow the department to present on Public Service Amendment Bill negotiation mandates from our provinces. Thank you. Over to you, officials. Moss, who's presenting? I see the movement of agenda. I don't see any presentation.
Chairperson.
Mr. Manela, are you there?
Chairperson, yeah.
Yeah.
Can you hear me, Chair?
Yes, I can hear you.
Chair, in terms of the agenda, it is structured as follows, Chair. Just to allow members just to table their negotiating mandate on the two bills. Then after, it will be the department now to formally respond to the negotiating mandate, Chair. I'll propose that the Chair just allow members officially to table their negotiating mandate with regard to the two pieces of legislation. Thank you very much, Chairperson.
Okay, let's do that, but it is not how it is structured, but we can do what you are proposing. Here, it's not the members who starts. So we can swipe the items. Honourable members, let's start with the province.
Chairperson.
Chair, if I may just comment, please.
Yes, Honourable Badenhorst, then Honourable Whip.
Chair, if I may just... Thank you, Chair. Thank you for your indulgence. If just as a way forward, can I just ask that the administration then flight the negotiating mandates of each province, and then that the members, the delegates of each province, then just enter the table their mandate as per what's flooded on the screen, just for the sake of record, and that'll probably make it easier for everybody and faster. Thank you.
Yeah, you are correct, Honourable Whip.
There's someone who's disturbing. Moss.
Moss, close your mic, mute your mic.
No.
Yes, Honourable Whip.
Thank you, Chairperson. I was saying we have just adopted the agenda. So I was proposing that the departments start first, then we come later after the department is done with the presentation. So I don't think it's right for us to just amend the program while we've just adopted it the way it is.
That's how it's supposed to be. I don't know what was the intention by Mr. Manele to start, but are we able, Mr. Manele, to flight the provincial mandates, or we have a crisis?
Chairperson, with your permission, I have just now shared the folder on the negotiating mandate in relation to public administration and management amendment bill. I'll also forward the folder with regard to the second bill.
Let's start with the first one, Mr. Manele. Don't mix the things. The agenda is very clear.
Okay.
There's no confusion about the agenda. The agenda says public service amendment bill. So let us not mix things. Agenda is properly done.
I'm forwarding, Chair.
Yeah, let's flight it.
Chair, I've just now sent the folder to Ms. Slatana. She will share the folder with regard to the first bill, Chair. Thank you, Chair.
Colleagues, are you able to flight? It has taken more than 3 minutes now. We are just waiting for this thing to appear on the screen.
The negotiation mandate.
Okay, I think that if I may come. Chair.
Yes, Honorable Kaiser. I was trying to sort this thing out of the screen. Honorable Kaiser.
No, Chair, I think we can proceed with our negotiating mandates, as you have said, because now the chief whip has just adopted the agenda, and then now we can't wait such a long time to have our negotiating. We do have them on our devices. We can read them from there and proceed. That's just my suggestion for procedure.
Yeah, but for the record purposes, Honorable Kaiser, because this meeting is recorded, then that's what we wanted. So it should appear on the screen. We do have on our page, but we wanted it to be here. Can we allow the presenter to present?
Can the presenter indicate the name so that I can give them sharing rights, please?
Yeah, we seem to be disorganized today. I don't know what is happening. And I don't think it's acceptable. We knew that we'll have a meeting. So we don't seem to be organized. We don't seem to be doing what we know that we're supposed to be doing. Mr. Manele, what is happening? I really don't understand now. We call for a presenter, no one is responding. Okay, Flight It will do it as members from provinces because there's no present. Just Flight It will start with the first province. Do we have representatives, Mr. Manele, who can do presentations? Umgileke noManele manje.
Chairperson, I'm connected. I'm from the Chairperson for Premier's Office and Legislature. I'm also on. Thank you.
Thank you very much. Can I have a few moments? Usita, are you there? Usita, are you there?
Good morning,
From
Chair.
Service.
Yes, good morning, Chair.
Morning.
Yes, I just want to first, and good morning to the honorable members, and good morning to our Minister, Nkosi Buthelezi, is present. Good morning to our Director General, Mr. Vukela, our DDG, Ms. Linda Tludla, and our colleagues from the department. I don't know, Chair, if our Minister would want to introduce the team, if that is, we could give him the platform before we begin.
Okay, no, sorry, Honourable Minister, I could not recognize you on the list. I thought you were in the cabinet, but let's welcome you and appreciate your presence to this meeting. If you will start with your political introductions and the team present, let's hand over to you, Honourable Minister. Ngangele.
Thank you very much, Chair, and greetings to my colleagues who are your committee members. I think there isn't much that I want to say because we all know what we are about to do now. I will simply request that the team from TPSA simply shoot straight to the presentation so that we don't repeat ourselves. Thanks.
Thank you, Honourable Minister. Usita, you can proceed.
Thank you, Chair. Chair, it is indicated that the host has disabled attendees screen sharing. Could they please allow us screen sharing rights?
Anyone who's assisting?
I'm working on it, Chair.
Our apologies, honorable members. Really, we are disorganized today. Our apologies for that. The sharing rights, are we willing to allow her to share the screen?
Everybody can now share, Chairperson. I've given everybody the sharing rights.
Yusita, are you able to share now?
Yes.
All these things should be done before the meeting starts. It can't be the duty of the meeting to allow the sharing or disallow the sharing.
I have shared. Is the presentation visible?
Yes, it is on my screen.
Thank you, Chair. I will be doing the presentation on the Public Service Amendment Bill of 2023. Just as a brief background, the bill was submitted to Parliament on 31st of March 2023, and the Portfolio Committee made changes in 2 clauses at the A list in the bill and adopted the amended bill on 14th of February 2024 and referred it to the National Assembly thereafter. The bill was adopted by the National Assembly with amendments on 27 February 2024, and it was presented to the National Council of Provinces as a B list. The bill was then revived and referred to the Select Committee on Cooperative Governance and Public Administration on 30th of July 2024 by the NCOP following elections. The NCOP then referred the bill to the provinces, and briefings on the bills were held in the provincial legislatures, and public hearings on the bill were also concluded, the last one being on the 10th of June. The Select Committee also held oral hearings on written public submissions on the bill on 22nd of July 2025. The Departmental and Parliamentary Legal Services responded to the written and oral public consultations on 2nd September 2025. And the department is before the Select Committee today to present departmental responses to the negotiating mandates on the bill tabled by the provinces. So in respect, I will go through the province to the negotiating mandates province by province. I will deal with the comments and then also our responses, the department's responses. So the Mpumalanga Provincial Legislature, the Oversight Committee on Legislature and Premier's Office voted in favor of the bill without proposed amendments.
Sorry,
However,
Sita, your screen is not moving. I don't know whether it's my gadget, but I'm looking at the beautiful building of the department. It is beautiful. So now I'm only seeing when Ngangelele sits. we are not seeing any content.
It's moving on my side.
Honourable members, is it my screen only, or you? No, now it's moving.
Jed, it might be of assistance if the presenter puts the slide into slideshow mode, so it fills the whole screen. So it might help.
Okay.
They will give us a project plan. Let me call the service provider and hear what is the status about the PMS.
Okay.
So because if we do not actually get into the PMS,
sorry, who's addressing us now?
It's not going to assist. Just go with the name.
I gonna get a salo.
Ubanos addressayo. Who's addressing us now? The last time we saw you sit now, who's addressing us?
It is your thing online. Is your
I hear service providers.
No, right, I will attend to you. So Neamba, uta number nini?
Aibo, can you mute your phone? Babu Nzimande.
We are at work. Hey. Come on. Hey. The same 17, guys.
I don't know what's going on, but angathi baloyiwe namhlanje.
No, I think that means should move everyone. I think they are all.
Jacinta, are you still there? Jacinta is still there. Oh, I won again.
My chairperson.
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 Yes, Honorable Peter.
May I have a proposal, Chairperson, to reschedule this meeting for another day? Because now
No,
it
we
seems
don't have such a comfort. Unfortunately, if we reschedule, we won't have another slot up until next year.
No, I'm sorry, Chair.
The schedule is tight. So once you postpone a meeting, you must expect that that meeting can be held next year. All right. Jacinta, are you back? Please talk to us.
Chairperson.
Yes, Mr. Manele.
Chair, there is a hand from our parliamentary legal service who's working with the department. Maybe we could just, with your permission, recognize that hand.
About Gengen. Yes,
morning.
we recognize your hand.
Good morning, Chair, and good morning to everybody on the platform this morning. Chairperson, I just wanted clarity to try and get this process running a little more smoothly. So we had agreed as a team with with Mr. Manele that with regards to the PSA the amendment bill, that the department would present simultaneously with legal. So what we did is we created one document where it has the mandate of the concerns of each province, together with the department's response, and then together on that very same page, it will have legal's response. And I just wanted to check, in the interest of time, if we are still going to proceed as agreed between department, myself, and the secretariat.
Yes, you agreed as a team on the approach. So if someone is experiencing a challenge, you must come in and stand in for that because you present as a collective.
Perfect. So then if the department is having a difficulty, then I could flight my presentation.
We have the sharing rights as well.
I'm going to check, if you could just bear with me. All right, let me try and do this. Chairperson, if you could just...
Yes, it does appear now.
Okay, perfect. Thank you, Chairperson. So the department was going to start with Limpopo Province.
Can you reintroduce yourself and show your face on the screen? And then you can switch off your video when you present is fine.
Okay, let me, one moment. Are you able to see me?
Members, are you able to see her? Because on my screen, I am unable.
We can't hear. The presentation we can see.
Or you're unable to see her?
Yes, the person.
All right, let me see.
Yeah, we can now see you.
Oh, perfect.
Yeah.
Good morning.
Good morning. You can proceed, yeah.
Good morning. So my name is Thiloshini Gangan, and I'm the Parliamentary Legal Advisor at Parliament, and I'm going to assist the department in presenting the comments and my apologies, the mandates, and then our legal responses, as well as the department's responses to the concerns. So let me start. I'm going to switch off my camera, Chairperson, if that's all right. Okay. So I'm going to start with the Mpumalanga Provincial Legislature. Their concern, the following comments and inputs were received from public and stakeholders. They had a concern regarding Clause 2, functions of the Minister and the executive authorities in terms of Section 3(7)(f), and they were concerned that the use of the word may rather than must in referring to the powers of the executive authority. And the DPSA's response to that was that the word may indicates the exercise of a discretion by the executive authority when exercising other powers conferred by the PSA Act. Section 42A(6) of the PSA delegations grants an executive authority the discretion to delegate to the HOD any power conferred on the executive authority by the PSA. Our response is that we are in agreement with the department's response. The term may confers a discretion on the executive authority to exercise that discretion in accordance with reasonableness and for the purpose for which it is required. To make this mandatory is onerous and problematic. Clause 8, change in employment capacity, Section 14A(1). The comment is that the word department should be changed to read institutions or organs of state. The DPSA responded to say, when the Public Administration Management Act 2014 was enacted, it repealed Section 15(1) of the PSA, which removed the state's ability to ensure that when employees of organs of state are appointed to the public service, they do not lose their years of service. Clause 8 therefore amends Section 14A to provide that the continuation of employment of a person employed by an organ of state in terms of Section 9 of the PSA and Section 14A(1) applies to an employee in the department, and Section 14A(2) applies to a person employed by an organ of state. So no amendment in this regard is required. And the parliamentary response is that we are in agreement with this, and both words department and organs of state are already defined in the PSA. The next province is the Northwest Province. The following comments and inputs were received. Clause 16, limitation of political rights. That is Section 36A, the new provision. Comment by the Northwest Province. Deletion of the proposed insertion of Section 16. Gasati has taken Section 56 of the MSA to the Constitutional Court to be declared unconstitutional as it infringes on the right of association as contained in the Constitution. The department responded to say that the definition of political office has been aligned in the Local Government Municipal Systems Act, and that political office in relation to a political party or structure thereof means the position of a chairperson, deputy chairperson, secretary, deputy secretary, treasurer, or elected or appointed decision-making position of a political party nationally or in any province, region, or other area in which the party operates, or any position in the party equivalent to the position referred to in paragraph A above, irrespective of the title designated to the position. The Constitutional Court upheld the Labour Court judgment in this regard, and so there's no need to limit the prohibition to HODs and to those reporting to HODs. This judgment reaffirms the position as taken in the bill as correct. And from Parliament's side, we are in agreement with the department. The Constitutional Court in the matter of South African Municipal Workers Union versus Minister of Cooperative Governance and Traditional Affairs and another, which was handed down in April 2025, found that Section 71B of the Local Government Municipal System Act is unconstitutional for imposing a total ban on junior municipal employees from holding office in political parties. The court upheld the broader right to hold political office, limiting the prohibition to only municipal managers and those directly reporting to them, as previously intended. The court found that Section 71B of the Systems Act restricts the political rights of municipal employees, as set out in Section 19 of the Constitution. It hinders them from fully engaging in political activities, while the purpose of professionalizing and depoliticizing municipalities is credible. The question is also, how can it be done without intruding so heavily on a fundamental constitutional right? And you will recall at the last committee meeting, this was what was discussed. It's about the balance. The next province, my apologies, we're still with the Northern Cape. So Parliament is in agreement with legal advisors, in agreement with the department. The limitation or prohibition on holding political office as contained in the MSA does not extend to lower level employees. The next province is the Free State province. The concern raised regarding regarding the devolution of powers to accounting officers, as these individuals are not elected. Some stakeholders submitted that powers should remain with the executive authority, who are elected representatives. However, there was no consensus reached during the public hearings, and while some argued for political oversight, others emphasized that politicians should focus on policy, leaving operational matters to the administration. The DPSA response stated that Chapter 13 of the NDP identified the need for the stabilization of the political administrative interface, and it was a situation of focusing on skills and professionalism will be ineffective unless the political administrative interface is clarified to ensure a clear separation between the roles of the political principal and the administrative heads. So the bill identifies and delineates admin powers to ensure that operational matters are at the level of HOD, and strategic powers must reside with the executive authorities. Checks and balances that are included in the bill, the head of department is accountable to the EA for the administration of the department and the functional area of responsibility. The head of department must report to the EA when required, and the head of department is to assist the EA to fulfill the EA's accountability obligations in terms of the Constitution. Also importantly, if a head of department refuses or fails to fulfill a power or duty as required in terms of the Act, the EA may intervene by taking appropriate steps to ensure fulfillment of that duty or power, by issuing written instructions of steps to be taken if the head of the department fails to take such steps. And the word may, just a note, was replaced during the previous portfolio committee process. Further, the Act must provide clear and direct delegation of powers to accounting officers to ensure that it doesn't solely rely on the discretion of the executive authority. That was the last comment. The department's response explains that once administrative powers are devolved to HODs, delegations won't be necessary, and executive authorities will continue continue to fulfill their policy and constitutional mandates. Delegations create instability as the executive authority then withdraws delegations based on conflicts with HODs, which hampers the efficient administration of departments. The parliamentary comment is that with the devolution of power, delegations will be superfluous, and we've just indicated that the department is better placed in practice to speak to the delegations as they've explained above. The next difficulty, concern from the province was that the definition of political office should be extended to exclude membership of a party's executive committee. And the department's response is that the proposal is noted and will be considered. Extending the scope of political office will require justification. And they've directed the issue to us as parliamentary legal advisors. My comment is that it is understood that a political party's executive committee is a central decision-making body responsible for managing and leading the party between its conferences, directing its policies, strategies, and overall operations. It appears, therefore, that this could be a position of power, and accordingly, the committee may want to consider including it in the definition. So this is something that the committee may want to look at. Moving on, next concern, clause 2, functions of the minister and executive authorities, section 3.7, seeks to substitute section 3.7 of the Principal Act to provide strategic powers to the EA and to remove administrative powers from the EA to focus on strategy and policy. We've responded to this at slides 9 and 10. And legal says the bill identifies and delineates administrative powers to ensure that operational matters are at the level of HOD, and strategic powers must reside with the executive authorities. Moving on to the next clause of concern, transfers within the public service, that's section 14. It relates to giving the head of the department authority to transfer employees from one department to another, and also within departments. The recommendation is that employees should consent to the transfer, it can't be unilateral, and the DPSA says section 14 3 of the PSA provides that an employee may be transferred under subsection 1 only, A, if the employee requests the transfer or consents to the transfer, or B, in the absence of such request or consent after due consideration of any representations by the employee, the transfer is in the public interest. Therefore, the PSA provides that the consent of the employee is required when requested by the executive authority to be transferred, and if consent is not given, the following due consideration of written representations by the employee as to why he or she should not be so transferred, the employee can be transferred if it is in the public interest. And we are in agreement with the department's response on that issue. The next clause of concern is clause 13, unauthorized remuneration, section 31. Section 31(2)(b) of the PSA allows an HOD to approve the paying out of revenue an amount equal to salary allowance, fee, bonus, or an honorarium to an employee. The recommendation is that benefits are negotiated at bargaining councils for employees. The department's responded by saying that employees who are employed by a department who are temporarily placed in another institution, secondments, in other words, so this section applies to secondments. The provision says that any salary, allowance, fee, bonus, honorarium payable to the employee is forfeited to the revenue whilst that person is not in the department. It further provides that the employee may, in exceptional circumstances, be allowed to retain these benefits. And this may arise where the secondment benefits is necessary for the department to fulfill its obligations. So in this circumstance, the discretion to allow the employee to retain that benefit will be permitted and authorized by the HOD. And the HOD is not permitted to create these payments at a whim. So the principle of legality and it must be the decision to do so must be justified. And I am in agreement with the department. The principle of legality, rationality, transparency, accountability are all applicable here. So there should be no danger of that. The next concern was clause 14, direction to perform other functions or to act in another post, which is in section 32. The HOD may direct employees to temporarily perform other functions within the department. The EA may direct the HOD to temporarily perform other functions with the department. There's a recommendation to insert a clause that vacant posts should be filled within 4 months. And then clause 14C in relation to acting in a post, the province says in relation to acting in a post, but the HOD is silent on remuneration. It must be clarified. And the next clause of concern is 14A, that an employee should consent to temporarily performing other functions within the department. The DPSA response, section 32 of the PSA does not deal with recruitment and appointments in the public service. Appointments in the public service are dealt with by sections 9 and 13 of the PSA. Further, Regulation 65(7) of the Public Service Regulations 2016 provides that a funded vacant post must be filled within 8 months after becoming vacant. Acting allowances are payable to public service employees in terms of the policy on acting allowance for senior management service and policy on acting allowance for personnel on salary levels 1 to 12, which are negotiated at the PSCBC. The consent of an employee is required to temporarily perform other functions within a department, and we are in agreement with the department's responses in that regard. We're going to move on to the next province. It's KwaZulu Natal. Following comments and concerns. Concern 1, clause 1, definitions of executive authority and head of department. The comment is that the movement of powers of executive authorities to the heads will professionalize the public service and will eliminate conflicts of interest between politicians and administrators. Dissenting views that some HODs may abuse these powers if they're not overseen by executive authorities. And we have dealt with this at slides 9 and 10, but just to reiterate, from legal side, we are in agreement with the department. If a head of department refuses and fails to fulfill a power, the EA may intervene by taking appropriate steps. To ensure fulfillment of that power. The next concern is that HODs must not chair recruitment panels and approve appointments of senior management service members. There's a concern that HODs must not chair recruitment panels and approve appointments of senior management service members. The department's responded to say, Chapter 5, senior management of the PSR and specifically Regulation 86 dealing with competency-based selection provides that the minister may issue directives on the selection processes for the filling of SMS posts. Chapter 2, recruitment and selection of the SMS handbook encourages good practice in the recruitment and selection of SMS members. An executive authority or his or her delegate will appoint a selection committee and make recommendations on appointments. The legal framework for recruitment and selection is provided for in the Constitution, the Labour Relations Act, the Employment Equity Act, and the Public Service Act, read in conjunction, in conjunction with the PSR. We are in agreement with the department's response in this regard. Next clause, termination of employment. Courts have found that both procedural and substantive fairness must be proven by departments when dealing with deemed dismissals. Section 17.3b is open-ended, dealing with the reinstatement of employees who is deemed to be dismissed in terms of Section 17.3a. The department responded to say that the bill seeks to amend Section 17.3b to provide that the head of department may approve the reinstatement of an employee who is deemed to be dismissed on good grounds shown. So in terms of Section 17.3a, an employee would be deemed to have been dismissed for misconduct if the employee is absent from work without their consent, without the consent of the head of their department for longer than a month. And this dismissal shall be deemed to have taken place from the date following the last day of the employee's attendance at work. So therefore, if the employee is absent from work without the consent of the head of the department, it would automatically trigger the application of Section 17.3a, and the employee would be dismissed for misconduct by operation of law. However, the employee may request to be reinstated in terms of Section 17.3b of the PSA. They've referred to some case law. So in the case of National Education, Health and Allied Workers Union and another versus McGladdery, the court held that the termination of employment in terms of Section 73 involves a two-stage inquiry, and 17.3a and 73b deals with adequately has this two-stage inquiry. Our response is that the termination of employment must be in accordance with the Labour Relations Act, as well as the Gazetted Code of Good Practice dealing with dismissal, Gazette number, dated 4 September 2025, which was last week, I think. And this clause deals with dismissals for absentia for a period exceeding 1 calendar month, and the reinstatement refers to good grounds shown. The next clause is clause 18, wrongly granted remuneration. The suggestion is that we substitute accounting officer with head of department, so delete the wording, but the employee shall have the right to be compensated by the state for any patrimonial loss which he or she suffered as a result of the discontinuation or withdrawal at Section 38(2)(b) 5, as employees who unjustly benefit from the state due to overpayment must not sue the state for patrimonial loss. The recommendation is to insert a clause to provide for consequence management against the head of department or employee who approves the overpayment. The department's response is that the PSA defines accounting officer, which is aligned with the PMFA, and Section 38 of the PSA also refers to accounting officer, so there's no need for the substitution of the term head of department. The wording of the proposed Section 38(2)(b)(5) in the bill is the same as 38(2)(b)(2) of the PSA and has not been amended, except that it now sits in the new clause. The provision in the PSA has not been subject to any interpretation challenges. It also should be noted that the error in the overpayment arises from the conduct of an employee in the department and is not ascribed to the fault of the employee receiving such overpayment. Consequence management is already provided for in Section 16A of the PSA and regulated in Chapter 2 of the PSR. We are in agreement with the department. Moving on, next province that we're going to look at is Gauteng. The general comments. The objects of the bill do not include the application thereof to municipalities. It provides for the devolution of administrative powers from the executive authorities to heads of department, but excludes the devolution of administrative power from municipal executive authorities to municipal managers, for example. The department's response is that the PSA regulates national and provincial spheres of government, while municipalities are governed, regulated by the Municipal Systems Act. PAMA traverses all three spheres of government and provides for the organization, management, functioning, and personnel-related matters in these three spheres of government. PAMA recognizes that the three spheres are interrelated, interdependent, and interconnected. The bill does not propose any amendments for the devolution of admin powers from municipal executive authorities to municipal managers. And from legal side, we are in agreement with the department. Municipalities are regulated by the Municipal Systems Act and related municipal legislation. Moving on to the Eastern Cape province, following comments and inputs, general comment. The issue raised by stakeholders relating to the bill should be given consideration by the department when formulating regulations. The department's response is once the Public Service Amendment Act is promulgated, the DPSA will consider the issues when drafting regulations. The next concern is clause 2C, functions of the minister and executive authority, again, section 3.7, and then clause 2F of the bill, which provides an executive authority may exercise other powers and must perform other duties conferred or imposed on the EA by this act. Must be amended to make provision for the peremptory changing may to must, and thus this provision must read an executive authority must exercise other powers and must perform other duties conferred or imposed by the EA in this act. The departments responded to say that the PSA outlines the duties of the powers and the duties of the EAs, which are contained in the various provisions of the PSA. The word may indicates the exercise of a discretion by the EA when exercising other powers conferred by the PSA. And then section 42A(6) of the PSA grants the executive authority the discretion to delegate any power conferred on the executive authority by the EA. We've already addressed the issue on our slide 2. Next concern was clause 12C, other remunerative work. Section 30 is proposed that 12C of the bill must be amended to allow the head of department a period of 60 days after receipt of the request from the employer to decide whether or not to grant permission for the performance of remunerative work outside. The current 30 days in 12C is insufficient. Yes, the departments responded to say that the amendment does not change, does not affect changes, in section 30, other than to substitute HOD as the authority to approve the work. The 30-day period is currently in the PSA and no amendment is proposed, and there's been no issue with this time. Our response is that whether it's 30 days or 60 days, it's really, a policy issue. In fact, most of the concerns from the various provinces are policy issues, and we as legal have just tried to assist with responses on it, even though they're policy, where we can. We're going to move on to Western Cape Province. Clause 2. The concern is that there was an ambiguity between roles of the president and premier versus ministers and members of the executive council. And the proposal is that we should clearly distinguish between the executive authority responsible for heads of department and those responsible for departments. And we need to specify whether it's ministers or members of the executive council remain accountable for the department's performance. The department has responded to say that the PSA amendment amends the definition of executive authority to provide for a definition in relation to a head of department, which provides that the appointment and other career incidents of heads of department and government components shall be dealt with in the case of A, a head of a national department or national government component by the president, and B, a head of the Office of the Premier, Provincial Department, or provincial government component by the relevant Premier. The proposed amendment to this Section 3.7 of the bill provides that an executive authority is accountable for the department in his or her functional area. There was a need to strengthen the provisions to allow for enough checks and balances to limit political interference while recognizing the need to ensure that public administration delivers and that departments support the EA's accountability and responsibility obligations as per the Constitution. The department goes on further to say that certain checks and balances included in the bill are the following. The head of the department is accountable to the EA for the admin of the department and the functional area of responsibility. The head of the department must report to the EA as and when required, and the head of the department is to assist the EA to fulfill the EA's authority, accountability obligations in relation to the department and in terms of the Constitution. And lastly, if a head of a department refuses or fails to fulfill a power or duty as required in terms of this Act, then the EA may intervene by taking appropriate steps, as the case may be. And we are in agreement with the department regarding their response. Moving on. Clause 4, devolution of powers to heads of department. The concern that there's an excessive transfer of human resource management powers from the EA to heads of department and it undermines accountability. The proposal is that we retain executive authority's powers over appointments of deputy director generals and heads of department, and that you require EA authority approval for all senior management appointments, and that you maintain executive authority's disciplinary powers over heads of department. The department has responded to say that the proposed vesting of powers to an HOD comes from the NDP plan, which proposed stabilization and to clarify political administrative interface to ensure clear separation between the roles of political principals and administrative heads. Amongst the policy imperatives addressed in the bill was stabilizing political administrative interface with a focus on professionalism. And at the NDP, it was reflected that this would be ineffective unless political administrative interface was clarified to ensure clearer separation between the roles of political principals and administrative heads. The national framework towards professionalization of the public sector, as adopted by Cabinet, also aligns with policy direction adopted in the bill. And there's an extract that they've included. It says, among the key aspects in the latest changes to the Public Service Amendment Bill are formalizing some of the recommendations of the NDP, including devolution of the administrative powers to HODs to ensure alignment with the financial responsibility as prescribed in the PMFA of 1999. This is intended to unburden the executive authority to focus on only strategic issues and policy direction. This is long overdue. Finally, the tension between the Public Service Act of 1994 and the PMFA of 1999, which studies have shown have exacerbated tensions of the political administrative interface, is now set for settlement. The bill seeks to provide for the devolution of administrative powers from the executive authorities to HODs. This arrangement is critically important for institutional efficiency and effectiveness. The executive authorities therefore retain their strategic leadership and policy direction. And then our response is that to balance power, the committee may want to consider executive authority powers over appointments of deputy General or heads of departments, requiring executive authority approval for all senior management appointments, and maintaining executive authority disciplinary powers over heads of department. That is obviously up to the committee to decide on. Clause 7, responsibility, heads of department concern, overly broad admin powers without sufficient checks. Proposal, require quarterly reporting to EAs on all HR decisions and establish an independent review mechanism for continuous appointments. The department's response on this issue is that they've responded to this concern on slide 2. And then certain checks and balances included in the bill are the following. The head of the department, and I just reiterate, we've dealt with this before, the head of department to be accountable to the executive authority for the administration of the department and the functional area of responsibility, and the head of department must report to the EA as and when required. The head of department has to fulfill and assist the EA in the EA's obligations, and the head of department, if they refuse, then the EA may take steps. The committee may want to consider additional checks. However, it must proceed cautiously to avoid impeding or burdening the administration. These considerations may be more appropriately addressed through regulations. We are in agreement that there are sufficient checks and balances. The next concern was clause 10, the selection panel composition, potential for political interference in board appointments, and the proposal is that we replace political office bearers on selection panels with independent experts and implement parliamentary oversight over the appointment process. The DPSA says that the proposal is noted. The DG presidency is intended to support the appointment of HODs once the amendment is effected, and these matters will be revisited when the regulations to support the PSA are being drafted, and we are guided by the department's assurance in this regard. The dismissal powers concern is that the removal of the EA dismissal powers creates accountability gaps, and the proposal is to restore the EA power to dismiss underperforming heads of department and to establish clear performance benchmarks for dismissal procedures. The department's response is that the appointment and career incidents of HODs are vested with the president or the premier, which ensures that HODs are managed outside of the EAs. This measure mitigates the political administrative interface between HODs and EAs, and that section 12 of the PSA deals with career incidents of HODs, and chapter 7 of the SMS handbook deals with misconduct and incapacity.
Oh, sorry, ma'am, before you proceed.
Yes.
I think in the last week meeting, we dealt in details with the department responding to each and every item Western Cape have raised. Maybe if you can allude to the aspect of your report where you have a different view with the department. Otherwise, when you are agreeing with the department on what they are presenting, you can just browse through that, because we dealt with this
yes,
in the previous meeting.
Okay, that's fine. Chairperson, if we deal with it that way, then there's no disagreement. We are in agreement with the Western with the department's responses in respect of the Western Cape, and then it's just the Limpopo province.
Yes, you can deal with the other provinces because they were not there. We
yes.
only dealt with the Western Cape.
Correct. The Limpopo province wanted amendments to clauses 11, 14, and 16, and the department responded to say that there were no proposed amendments to clauses 14, 16, and 11. It wasn't indicated in the mandate received, and we are in agreement with that. We didn't see it. And then lastly, Chairperson, there are typographical errors that I just need to alert the committee to, which we will fix. So in clause 2, the proposed amendment to section 32 erroneously removes subparagraphs B, which we intended to retain. And in clause 13, amending section 31.3, it doesn't reflect a bold formatting of the terms of this act and determination of the minister and section 30B as they appear in the current act. So we'd have to rectify that. And clause 18, the amendment refers to substituting subsection 2, whereas actually it's subsection 1 that is being substituted. So these are just typographical areas that we'll fix, but we do need to alert the committee to it, and they are not substantive changes. And then further, clause 1B and C, we're going to correction of the inverted commas of head of department, etc., to include single inverted commas, and the same in respect of political office. Clause 2 on page 3 of the bill, lines 44 and 56, we should consider changing must to shall in order to be consistent with the rest of the wording in the Principal Act. Clause 2 on page 3 of the bill in line 49, the word RHE must be replaced, must be changed to the word the. Clause 4 on page 4 in line 50, we should consider changing must to shall once again in order to be consistent with the rest of the wording of the Principal Act. Clause 12, the proposed amendment to section 32 erroneously removes subparagraph B, which we intend to retain, and this oversight will be corrected. Clause 13, this clause amends section 31.3, and it doesn't have the bold formatting of the words this act, determination of the minister, and section 30B as they appear in the current act. Clause 16 on page 10 in line 12, we should consider changing must once again to be consistent with the rest of the wording in the Principal Act. Clause 18, the amendment refers to substituting 2, whereas actually it's subsection 1 that's being substituted, just repeating the previous. And then on page on clause 18 on page 11 in line 6, we should consider to insert the word and. Those, as indicated, merely typographical issues, which we will easily correct. Chairperson, that is the end of my presentation. I sincerely hope that I have assisted the committee and that we have moved, I think we've moved fairly swiftly regarding this bill. Thank you, Chairperson.
Thank you very much. You have assisted us in great deal and to try and be within our allocated time. Thank you for your intervention. That's what is meant by collective efforts. When the other partner is experiencing challenges, you come in. Thank you very much for that. Honorable members, we'll request that the team flights the provincial mandates as requested before, because already there is a constitution of provincial mandates. But if there are comments by honorable members, will allow that to take place. Will be guided if we can go against provincial mandates that are going to be tabled here today. Let's take Honorable Nzimande. Before Honorable Nzimande, let me take Honorable Minister. Then Honorable Nzimande will follow Honorable Minister Ubtelezi. Inkosi Ubtelezi. Over to you, Ngala.
Thank you very much, Chair. Also, greeting for the second time. I just wanted to ask that the committee try to look at all this presentation and make sure that they use their fine comb to go through all the comments by different provinces. But there's just one, what we call, point I want to highlight here, which says that when you look at the whole presentation, the only area which seemed to be of concern to some provinces is in relation to the issues of the powers of the AAs and also the delegation of such. My contribution in that one is that when you look, because we have dealt with this as a department, but I think it's fair to mention here that when you look at this very same proposed amendments in relation to EA's power and all that, they are more based on assumption. That is something I need to put on record here. I will make one typical example to say already we've got the delegations by EAs to HODs, which therefore the bill suggests that that's not enough. When you look at the reason why, the answer is that EAs simply takes these delegated powers from HODs willy-nilly, as if they just wake up one day and feel like we don't want to continue have these delegated powers to HODs, then they take them. But when you go deeper and check, because in the presentation here, there's a slide that emphasizes the importance of HODs now to delegate powers to lower levels, meaning EAs cannot delegate. All their powers should be removed from them to HODs, but the HODs therefore can later delegate them. Therefore, the question that the committee should ask itself in its deliberation is that, does it okay that HODs also delegate powers, and then when they feel like taking them back, they do so? Because we shouldn't begin from a point of view that suggests that that is only one-sided. It happens with the EAs. Because I asked the department to actually do a research that can actually help us, in particular myself, to understand as to how many this incident has happened where EA has delegated powers and then all of a sudden decide to take them back. That was never given to me. I will make, therefore, an example in the Department of Public Service Administration now, the one that I lead. I discovered that there were powers that were vested within the DG, and then the DG delegated them to some DDGs. And for some reasons, those powers were taken back from those DDGs to the DG, which resulted in serious instability in the department. This is the department that I'm leading. All I'm trying to say here is that what appeared to be a challenge, a perceived challenge from EAs, is happening twice with the departments, like HODs or Director Generals. So therefore, the assumption that it only happens with the EAs, of which I was never favored with evidence of that, may not necessarily be something that should guide us in reaching particular decisions. So all I'm trying to say here, Honorable Chairperson, is that this area is one that is mostly contested, which warrants us to apply our minds so that we do not end up passing a piece of legislation that will frustrate the same operations of government, or that will defeat the same purpose that we want to actually achieve. Even the assumption, therefore, that suggests, which is not spoken, it's silent on the presentation, but when you see through, it suggests that EAs are not fit and proper, and they are not professional in their approach. Hence, some of these powers needs to be removed. And that view needs to be looked into as to whether it is a correct view or it's an incorrect view, so that we are fully aware of the decision we want to take when it comes to this piece of legislation that we are discussing. That is just one part that I wanted to overemphasize, to say we should not assume that EAs are unprofessional. They are the source of problems. Hence, I'm citing a typical example in my department where this instability, which is cited as if it occurs as a result of EAs, it also occurs as a result of Director Generals who does the same of what is alleged to be done by EAs which I've never been favored with evidence of that. If I'm making sense, Honorable Chair. Thanks.
Thank you, Honorable Minister. Although it's now complicating our our engagements, because the initiator of the bill that is before us is the department. Now the department has responded to such arguments that have been put by other provinces as well, but it's fine. Let's engage on the matter. Honorable Nzimande.
No, thanks, Salo, and greeting to the minister. And partially, I agree with the minister, knowing the complications in the public service, and that obviously the act that we are working on shouldn't create more complication. But the other aspect which I want just to check, it's whether the matter of delegation will be dealt with thorough and correctly in terms of the regulations, or it may
You can switch off your video, Honorable Nzimande, so that we can get you clearly. I can see that you've got some
in the
technical
whether delegated powers can be delegated twice. That's one aspect. Secondly, I want just also to check whether really the department feels so much merit to keep the Section 17, the one that deals with the dismissal owing to operation of law. I will explain why am I asking that question. There are two issues there. Is that the situation on the ground enabled or create some inconsistencies. Workers will always come back on the last day of the 30 day, which makes it difficult to be fired. Then you'll have to follow another process, whether to discipline or so, where obviously they will table the reasons, whatever reasons they table. But you will have dismissed somebody who have absented himself for just 5 days, which is a problem. Why can't we just deal with the issue of absenteeism as one of the misconduct or part of the misconduct in terms of Section 17B? I'm just asking that question. But the second question that is linked to that Section 17 that deals with operation of law is that, do you, as a department and the local service, understand the powers that are there for the HOD as now proposed, as outside of the functus official doctrine, where obviously you think they can revisit their own decision? If not, then why do we complicate things for workers? Because obviously the LRA will not defend or protect them in terms of submitting the unfair dismissal. It means they must either approach the court, and you know very well the financial situation of our people. Approaching court is too expensive. You're making life so difficult for people, and in particular those that are living from hand to mouth, not to get justice. That's why I'm asking whether really, are you cemented to keep this section the way it is, and but just changing who the power will not lie to, no more the EA, but the HOD? Thank you.
Thank you very much. Any further comments, members? So let's allow the department and legal unit to respond. I don't see any further hands. Can we invite responses? Oh, sorry, there's a hand, Honorable Berenhorst.
Jay, sorry, I might have missed it in the presentation by the legal advisor, but I just wanted to ask if there has been, in fact, a comprehensive assessment on the impact of this bill on provincial finances, service delivery, and labor relations in provinces across the board. Thank you very much.
Thank you. Can we get responses?
Yes,
Sorry, before
thank
you
you.
respond, I see another hand. Honorable Eza, Honorable Skirkocher. In that order, please.
No, Chair, thank you very much. I just wanted to check, man, because I'm confused now a bit. The minister says that, but I don't want to. I want to be patient with the manner in which I quote the minister here. But ultimately, he says that there were powers that were delegated to HODs before, not during his tenure, and the HODs then delegated those powers to the DDGs. What perhaps is there any information from the department, since the department was here all the time, as to what could have led to the abdication of the delegated powers of the HOD to the DDGs, so that I get to understand the flow of the delegated powers to the DDGs of the department in terms of the submissions of the provinces on that part. And then I wanted to ask whether the department and Parliamentary Legal Service anticipate tabling of proposed amendment in both bills in line with the amendments proposed by the different legislatures. And perhaps the last one, if the establishment of a dedicated secretariat would bolster the PSC's ability to monitor compliance, investigate irregularities, and enforce ethical standards across public services, in line with ensuring rigorous accountability mechanism to address systemic inefficiencies within the issues that were raised. Chair, those are mine. Thank you very much.
Thank you, Honorable Iko, followed by Honorable Memang.
Thank you, Chairperson. I just want to find out, okay, are we now, that's more a procedural question, it's not about the presentation. Are we now going to consider the provincial mandates, and then after that we have our general comments, let's say opposing, not opposing? Is that going to happen here today, or are we just considering what the different provinces have presented as per their mandates? Thank you, Chair.
Thank you. Honorable Memang, you can come in.
Thank you, Chair. Chairperson, I was also on the, let me also start by first appreciating the presentation from the legal advisor. Mine was also on the on procedure. I thought you will revert to the department just to confirm what has been presented by the legal advisor as a collective work that they have agreed upon, and then thereafter allow provinces to present the mandate, and thereafter also probably as part of the report, get a sense from us as to whether do we affirm, because obviously I think where the department and the legal services agree, it then gives us, it makes our work much more easier in terms of the next level, whether it is C-list or not. Then we are then able then to take the report back to the parliament, to the legislatures to get the final mandate. I'm just a bit worried in terms of the the direction that the discussion is taking. But lastly, I think what Honorable Minister is raising, I think it's a matter probably that could be taken up after this bill has been passed by Parliament, because we are dealing with what has been referred to us from the NA. The public has commented on the bill that we have that we have referred to provinces. They are negotiating, and anything new could probably create a bit of a challenge for us in relation to the public involvement, because the area that the minister is raising, I suspect it's a matter that we can deal with it after the bill has been passed. Thank you.
Thank you very much, honourable members, for raising your concern in terms of the procedure, because we held an opportunity in the previous meeting to engage the department on those issues that are before us. And as you have said, Honourable Mimang, that maybe when regulations are formulated on the implementation of the Act, some of the issues may find expression, but of course, they can't be contrary to what is captured in the Act. They can't contradict the Act, but they can enhance the implementation of the Act. But with the procedure legally, can you come in if you will be able and the department to respond to the issues raised, or we can just move straight to the provincial mandates, which we can't contradict as well as members because they are from our provinces.
Can I just clarify one thing that was asked in relation to my contribution so that members are not confused?
Okay, I can allow you, Honourable
Yes.
Minister, to clarify that.
Yes.
You can
Yes.
come in.
It's just that my presentation was not suggesting that or was not trying to influence the committee. All I was just trying to say, I was highlighting the areas that appear to be of concern in different provinces in the main. So when I was, as a member, was saying that I was saying there was powers that were delegated to HODs and then further to DDGs, not necessarily that. I was highlighting a point that says the issue of instability, which is said to be caused by EAs having delegated powers to HODs, and then at a particular time they will take them back. I was highlighting one point to say that is not only limited to HODs, to what called EAs. Such also happens if you look at the administration itself, where you will find that a HOD or a DG may delegate a function or a power to his or her subordinate, but because of some other issues or reasons, then he or she may decide to take them back, meaning that it's not only limited to EAs, as that is what is suggested. It happens across the board. So saying that the committee should apply its mandate, as I said, use your fine comb to say there are also these discussions that have taken place which reveal something different, not in terms of saying it does not happen, but to say it happens across board. So that when we pass legislation, if we're under the impression that EAs willy-nilly wakes up and then take powers back, you can also trace such in terms of HODs and Director Generals in the administration part. That's what I was trying to highlight here. Thank you.
Thank you very much. Yesterday in the Public Infrastructure Committee, the Minister also indicated from the President that there is a bill which is being processed, which will also regulate the interface between the executive and the administration so that on the professionalization of public sector, but the roles are clearly defined. We hope that that will still come to us after the NA. Then we'll also process that in due course immediately once it gets deposited to us as NCOP. Honorable members, let me check the department. Department, are you in concurrence with what your counterpart have presented, the legal unit?
Yes, Chair. We concur with what has been presented from our side and the Parliamentary Legal Advisors side. If my Chair can just grant direction, do I respond to the issues, the matters raised now?
If you look at your responses, they've adequately responded, but to those clarities, you can respond to them. But we are not reverting back to initial discussions.
Okay, Chair. Okay, thank you. I think one of the most pressing matters that were raised were regarding the delegations, whether we are delegating twice in essence, and also, so I think just to give a background regarding delegations, although the Act provides for delegations at Section 42A of the Public Service Act, the Minister has issued, a previous Minister has issued a directive, and this directive is a directive on public administration delegations of 2014. And this directive, the purpose of the directive, it actually emanates from, I think, from it is to implement the cabinet that approved the principal document by determining norms and standards for delegations in terms of the Public Service Act and the Public Service Regulations. So the directive is a legal instrument that is issued in terms of the Public Service Act, and it carries and it elucidates also the Public Service Regulations. So the directive makes provision and it provides a framework of how delegations should be looking, where they are delegated from the EA to HODs, and then from HODs to other functionaries in the departments, DDGs, or from DDGs to lower level employees. So that is a legal document that prescribes how delegations should take place, and this directive is applicable to all departments in terms of the PSA across the public administration in terms of national and provincial and local government, and it prescribes how your delegations should look so that they comply with the principal acts. Then I think the other issue that was raised was the issue of the PSC and the mandate in terms, so the PSC derives its mandate from Section 196 of the Constitution. So the PSC has a, and if I can just refer to that constitutional section, it says that the commission is independent and must be impartial. It must exercise its powers and perform its functions without fear or favor or prejudice in the interest and the maintenance of effective and efficient public administration. And it goes on to say at subsection 4 that the powers and functions of the commissions are very clear. It says that it is to promote the values and principles set out in section 195 of the Constitution, which deals with public service. And then it also is to investigate, monitor, and evaluate the organization and administration and the personnel practices in the public services. So it has an investigative mandate already in terms of the Constitution. And then regarding the department, I think one of the issues there was regarding HR-related matters and how they intervene in terms of what is their role in terms of appointments and recruitment procedures. And in terms of the constitution, it's clear that they have then only an oversight function, so they don't interfere with departments' recruitment and selection processes. So I think I've addressed all the issues there. Thank you.
Thank you very much. Honourable members, let's go straight to the provincial mandates. They are flighting the provincial mandates. We'll ask each and every member not to read the entire mandate, but just to confirm the provincial mandate. Then we move to the next member. Are you able to share the screen?
Yes, Chair. Hi, please share the screen, Chair.
Thank you. I thought we'll be referring to those letters which are signed by the premiers as provincial mandates. Do we have those letters, Mr. Manel?
Chairperson, the folder has been opened. It has all the provinces negotiating mandate. You can just indicate which province we are calling, then we'll open that one. We've got Eastern Cape, Free State.
Open the province, any province. There is no.
Okay, Chair. Chair, we'll start with Eastern Cape, Free State, Gauteng, just like in terms of that arrangement, Chair.
There are letters which are signed by the premiers, if I'm not mistaken, which are deposited to the NCOP as the confirmation of provincial mandates. I think that's what we are looking for. That's what I saw in the public infrastructure when we were dealing with the final mandates of provinces.
Chairperson?
Yes.
It's Roshni Gangan from the from Parliament. Maybe I can assist. Oh, there we go.
Yes. Yes. Invitation to a meeting. I know, no. That one deals with the invitation.
We scroll down, Chair. There's an attachment of negotiating mandate.
Oh, okay. You can scroll down. Okay. Will be interested on the part which says they support or they are not in support.
Chair, if I may be of assistance, yeah, it's normally the cover. We've scrolled past it. It's normally just below the logo of the province. There's a letter addressed to you as the chair of the committee, and the negotiating mandate is normally just below that.
Thank you, Honorable Badenhorst.
So in this example, if they scroll down, if they just scroll down a little bit.
Is this one?
There, yeah. One. Yeah, so under point 1 is to negotiate. Just that point 1.
Point 1, we are on point 2.
There, yeah, point 1,
yes.
just below it, just below point 1B. Yeah, no, I've just missed it. Sorry, Chair. I just missed it. If you just go up again. A little bit more.
Yeah, in favor of
there we
the
go.
bill.
Number 1.
Yeah.
There we go. The vote. So the delegate will just read the vote in the legislature.
Okay. We are starting with Eastern Cape, Honorable Peter. Over to you. Just deal with that section only. On item 1.
Oh, thank you, Chair. And must I summarize it or must I read it as it is?
No, you just say the province supports because it's there.
Oh, thank you, Chair. The Eastern Cape Province is in favor of this bill as proposed and amendments. Thank you, Chair.
Thank you. That is done. That is Eastern Cape. The next province. Yeah, we can see you there, Honorable Peter. You were politicking there, the gesture. Budli politik pamhlekazi. Lesa sithombe siyakubona pha. Next province. Free State. Let's move to that section. Ngathi susezantsi kakhulu. Intoni le man? Let's move up. Let's move up, people. Dr. Mthimkhulu. Let's move a little bit up. Dr. Mthimkhulu, are you there? Dr. Mtimkulu. Mr. Manela.
Chairperson.
Can you help us? I don't think we must waste time. We are wasting time now. We are still going to be dealing with the second bill.
There is a section that deals with conclusion that summarizes what the mandate is all about to a permanent delegate of Free State. Just go to that section. The one on conclusion, just go up again. Yes. Chairperson?
Yes.
If I may assist, Chair, if you look at the content of the negotiating mandate from Free State, the negotiating mandate from Free State provides a report of stakeholder engagement and some of the proposal. The conclusion says the National Council of Provinces should consider the inputs made by the stakeholders. In summary, some of the amendments, they were proposing some, amendments, Chair.
But it doesn't indicate whether they are in support
yes,
or
in
they are
terms
not
of construction of it does not, but just say that NCOP should consider the inputs made by members of the public.
There's no section which shows their support.
Yes, sir.
Chairperson, I was just informed. I think we must just look at the top of the document. Apparently, the mandate is at the beginning of this document, Chairperson.
Like the previous one.
Chair, the format is always the same. The mandate is normally summarized just below the logo of the province, just below the section where it's addressed to you as the chairperson of the committee.
Open the logo there. Start from the section of the logo.
Right at the top of the document.
Yeah. Don't move fast there. Let's see if it's not covered.
I think legal said in their presentation that the Free State did not support this. Maybe they can just... Yeah, there we go. There's the negotiating mandate just below the date of deliberation, 7th of May. If they scroll down a little bit.
Vote of legislature. Can you go a little bit up?
There, that's it.
The portfolio cooperative office is designated by Free State vote in favor. So let's request Honorable Dr. Skirkocher to confirm the
Thank you,
provincial mandate.
Chairperson. The mandate of the Free State, vote of the legislator, the Portfolio Committee on Cooperative Governance and the Office of the Premier has designated that the Free State legislator votes in favor of the bill.
Thank you. Thank you very much. Let's move. We now know what we are looking for. Can you just zoom to the next province and zoom to that section so that we save time? The format is the same from all provinces.
Chairperson, I think there is a mistake there. They are in favor of the PAMA Act. If you read that section.
Can you revert to Free State? So it's another mandate, not the one that we are dealing the PSA. No, where we read the mandate on top. Is it a new presentation or is it the same presentation? No, this is Gauteng. Can we revert to Free State? Because we are being corrected. That is not the same bill that we are dealing with. Maybe we had to open the PSA one. They are two different bills.
That's why I said I heard the legal advisor saying that the Free State was against this bill during the presentation.
Yeah, they must open that. We want to see that for the records. Look at the PSA amendment bill, not the PAM. We're still coming to PAM. Mr. Manel, you can communicate with Dr. Mtimkul over the phone so that you direct her, because these seem to be your emails. You direct her which one are we dealing with. Please, time is against us.
Okay, Chairperson.
Time is against us.
Chairperson, sorry, my apologies to interject. Could I possibly flight the mandate to assist?
Please.
All right. Let me.
This relevant bit that we are dealing with. Otherwise, we are wasting time.
All right. Can you see my screen, Chair?
Yes. Which province is that?
It's the Free State, Chairperson.
It's the Free State. Okay. Vote of the legislature. Can you move a little bit up? They are saying they're in favor.
No, Chair.
Or does not vote in
vote.
favor. Oh, okay. Yeah, they are not in favor. They are not in support. All right, that is Free State. Let's move to the next province.
Are you able to see my screen, share?
You are still in Free State.
Okay.
Now it's Gauteng.
The Gauteng Provincial Legislature support the Public Service Amendment Bill, subject to consideration by the Select Committee on the content as tabled. Thank you.
Thank you, Honorable Zimanda. That was so quick. We move to the next province. KwaZulu-Natal. Do we have a member here from KwaZulu-Natal? Because I'm the chairperson. Okay, I must read it. The committee met on the 23rd July 25 to consider the negotiating mandate report on the bill. The committee unanimously rejected the principle of the bill conditionally, as it takes away the powers of the executive authority in the ecological space of public administration. The legal mandate is attached here. Is it there?
No, Chair.
So
just bear with me. Annexure A. Let me just try and find that.
I don't want to say something which is contrary to my province.
Sure. I'm just going to have to. One moment, Chair.
It's fine. We can revert to KZN later. Let's move to the next province.
Sure. Let's do this. Share. Chairperson, we're looking at Limpopo. Are you able to see my screen?
Not as yet. If you can enlarge on your right-hand side.
Share.
The font there.
Is it visible now, Chair?
Yes, it is.
All right. Limpopo.
Are you sure it's not on the top section of the document?
My document
is at the end.
Oh, it's not the same like the others. Okay. Honorable Molokome. Committee recall negotiating mandate. Okay, Honorable Molokome, over to you. But where?
Can you go
or
down?
In support of the bill?
Yeah, we are
No,
in
no, no.
support.
The number.
Limpopo is in support of the bill, Chair.
Thank you
I
very
think
much.
yeah.
Okay, let's move to the next section, to next province. I'm sure we are recording, Mr. Manele, because we'll have to give the voting at the end. How many provinces? Which province is this? KZN.
It's Mpumalanga.
No.
It's
it's Mpumalanga. Okay.
Yes, one moment. It's Mpumalanga.
Honorable Ceza, it's your turn.
I can't see it on the screen, but I have it with me here. On the 12th of May, 2025, the date of deliberation, the vote of the legislature, the oversight committee on legislature and premier's office after consideration of the Public Service Amendment Bill B13B 2023 confers on the permanent delegate representing Mpumalanga province in the INSOP a mandate to negotiate in favor of the bill without any proposed amendments. Thank you.
Thank you, Honorable Ceza. Let's move to the next province. Northwest. Honorable Mabibo. Can we move a little bit up so that you can see the mandate? Or in favor? Oh, yeah, it's there. It's there. Yeah.
The
No.
The Northwest Provincial Legislature votes in favor of the public service.
Thank you very much.
Yeah.
Thank you, Hoshma.
We are in favor, sir, Chair.
Thank you very much, Honorable Mabiwo. Move to the next province, Northern Cape. Honorable Muimang, it's your turn, Chief Whip. Honorable Muimang, are you still there? Honorable Muimang, but we can all see for the records.
Thank you, Chair. I was struggling to unmute myself.
Okay.
The province on the 8th of 2025 voted in favor of the bill. Thank you.
Thank you very much. Yes.
Chairperson, these things are going to be very sensitive. Let's read the number of the bill, because look at that. I have the number of the bill being B13B, but the Northern Cape is B14B.
Yeah, it's the other one, is the PAMA instead of PSA.
Okay. Oh, there you go.
Yeah, but this is KZN now.
We must look at what it is.
Yeah, with the Northern Cape, can you revert to Northern Cape and have the correct bill? That was the second bill that we are going to deal with after this.
Yeah. Are we fine, Chair?
Yes, you can repeat.
Because the name of the bill is the Public Service Amendment Bill, which was voted on the 8th of May in favor. Is that correct?
Yeah, thank you very much, Chief Whip.
And Chair.
Is the correct bill?
It's a correct bill in terms of the name, but what is the number of this bill? Is it B13B or B14B?
B13. It's a typographical error.
No,
B13?
that's what I'm trying to raise here.
Okay.
Yeah, it's 13. No, you are correct, Honorable Kaiser.
Yes.
Because for the records,
that's why
with this, you can even go to court. So records must be properly done, recorded. This is not B14, it's B13 what?
Yes. I think in terms of the name of the bill, it is correct, and the legislature indicate that it is voting in favor. But we will request Manela to interact with the parliamentary liaison officer and the committee secretary just to make sure that this correction is made. Thank you, Chair.
Thank you, Honorable Chief Whip. Mr. Manela, did you capture that?
Yes, Chairperson, noted, Chair.
It needs to be corrected to mention the right number of the bill. Let's move to the next province. Same bill, Public Service Amendment Bill. Which provinces have we not covered?
Chairperson, we've covered all the provinces.
Or remaining KZN?
Correct. I've just reverted to KZN as requested.
Chairperson, if I may, the Western Cape is not being covered. I don't agree with that.
Yeah.
My apologies.
We voted on your behalf, Honorable Bennett.
My apologies. May we finish KZN and then?
Let's finish KZN, yeah. Just move it a little bit up so that we see the mandate. Yeah. The province is not in support of Public Service Amendment Bill. Okay, let's move. I'm carrying the mandate.
Looks like the chair doesn't want us to pass this bill.
Yeah, it's a contradiction. No, it's fine. Let's move to the Western Cape. Honorable Beden Host, it's now your turn.
Thank you very much, Honourable Chair. The Public Service Amendment Bill B13B of 2023, the date of deliberation was the 18th of June 2025. The Standing Committee on Premier and Constitutional Matters, having considered on the subject of the bill, referred to it in accordance with the Standing Rule 217, confers on the Western Cape delegation in the NCOP the authority to not support the bill in its current form and propose amendments as reflected in this report. The committee will reassess its position on the bill during the final mandate stage, contingent on whether the proposed amendments are considered. Thank you, Chair.
Thank you, Honorable Beden Host. Now we are done with the Public Service Amendment Bill. Can we get the voting results of provinces, Mr. Manel? Out of 9 provinces.
Out of 9 provinces, Chair, we've got 3 provinces that are not supporting. One, that's KZN, Free State, and Western Cape. And the 6 provinces that are in favor of the bill, supporting the bill.
Thank you very much. The bill is supported by the majority of provinces. Of course, noting those with reservations, the 3 provinces. Can we move to the second bill? I think the approach now will be different because, members, I am hoping that you have gone through these provincial mandates. You have seen the comments here and there, and we'll just request a legal section and the department to summarize what is captured there. Can we flight the next bill? Public management.
Can you see the bill?
Yes, we can see it.
Okay.
Can we go through it quickly?
Okay.
We can go up to 1:45.
Okay, thank you, Chairperson. I think the background is the same, which was how it was consulted with the PSA.
Just skip the background. Just zoom straight to what the provinces are saying. Yeah.
So Mpumalanga, their concern was they propose a correction of clause A where departments should be changed to read institutions or an organ of state. On the transfer of the public servants who determined the reasonable grounds for the transfer. Why are organ of state unfairly restricted from doing business with the state? Our response was to say there's no reference to departments in the proposed amendment of at clause 8 of the bill, which seeks to amend the PAMA. So section 1002 PAMA read the institutions to mean a national department or a provincial department, a municipal or national or provincial component. Further, the bill inserted the new definitions of organ of a state for the purpose of clarity at the section 8.1 of the PAMA. And then clause 2 of the bill seeks to amend section 5.2A of the PAMA, provide that an employee may only be transferred if, I need to remove this. Yeah, if reasonable ground exists. And then 5.2 of the PSA stipulates requirements for a transfer to take place. Transfer enables the mobility of employees across the spheres of governments where human resources deficiency exists or where operational requirements necessitate. An employee may only be transferred if is suitable, qualified for the intended positions upon transfer. That is, if he has a formal qualification, prior learning, relevant experience, capacity to acquire within a reasonable time, the ability to do the job. transfer are effected only with the consent of the employee, and there must be concurrence with the executive authority of transferring and recipients institutions. Transfer do not adversely affect the terms and conditions of employment. The provision ensure that the transfer does not interrupt the employee's continuity of employment, and that no employee may suffer any reductions in remunerations and condition of service unless the employee consent. Mpumalanga does not unfairly restrict an organ of state. Is that? Okay. So Mpumalanga, they are concerned. I think I'm repeating, Chairperson. The PAMA does not unfairly restrict an organ of a state from conducting business with the state. The insertions of a new definition of organ set in the bill ensure easier interpretations of the provision of Section 8 of the PAMA, which deal with conducting business with the state. The rationale for prohibiting an employee conducting business with the organ of state is to prevent conflict of interest and corruption in the public administration and to promote ethically behavior of employees. The Northwest, their consent is clause 2, individual transfer section 5. The bill gives more power to senior management and does not protect junior staff. The response is the section 5.2 of the PS stipulate requirements for transfer to take place. I think this is the same as we responded to Mpumalanga. Can I still read it, Chairperson?
No, let's keep it if it's the same response.
Thank you.
If it's the same concern from different provinces, and if you have already alluded to it, let's just keep it.
Yeah, even slash number 7 is the same response that we gave it to to Mpumalanga. And then the clause number 7 is a disclosure of financial interest, sections 9. Comment, disclosure of financial interest should be published and accessible on transfer of staff and interview. Our response is section 9 of the power deals with the disclosure of financial interest and is not part of the amendment to the said act. So the proposal are, however, noted and will be taken into account when regulations prescribing the manner in which disclosure are made and promulgated. Clause 8, capacity development by the institution, section 10.
Sorry, can you hold it there?
Okay.
Don't you have a collective like the previous one? We dealt with your responses and legal gave their response. Can we have that? Because we won't have time to allow you to finish and go back to legal and check. So can we have the joint presentation which reflects the response of the department and what legal says?
Unless the legal services they have it.
Yes,
Chairperson, it's Talani here from Legal Services. We had not done a joint response. We've done our own matrix format, but our responses are in agreement with the department. So we have the same responses. What I will do is when the department is done, I will just take the members through my responses very, very quickly, Chairperson. Members have had sight of my matrix and are aware of the contents of the matrix and have seen the various responses. So I don't think it's necessary for me to take members through each single response.
Okay, let's take it that way. You can proceed.
Thank you, Chair. Clause 8 is a capacity development by the institutions. The comment was senior management needs to ensure that entry-level staff members are enrolled and have access to courses at NSG. Capacity development government institutions need to be published. Our response is the bill seeks to amend 10.2 of the PAMA to provide that department must, within their available budget, provide a compulsive training that is directed by the minister to address the development needs of category of employees. And this includes entry-level appointments, who must attend, among others, the compulsory induction program offered by the NSG. Pillar 4, continuing learning professional development of the national framework towards professionalization of the public sector encourage that ongoing skill enhancements and professional growth for the public servants to keep them updated with the necessary technical skills and knowledge. The HRD and training units of the institution should actually ensure that information relating to the capacity development are properly captured for transparency and accountable purposes. Clause 9 of the NSG Section 11, their comment for Northwest, employees should have been part of the implementation of the bill as they understand the needs of the institution and what causes are needed. The role of NSG needs to be clarified. Who's responsible for the school? NSG should be at tertiary level. How is NSG configured to deal with the specific training as it is not of a higher education? Our response is the bill is extensively consulted publicly and included all employees in the public administrations. The NSG role mandate is derived from Section 195(1)H, which set out the basic value and principle for the public administration, including HRM and career development practices. It provides mandatory and non-mandatory educations, training, and developments to public servants across all spheres of government. Its mandate is to build professional, responsive, capable public sector through relevant programs that foster critical skills, promote ethical conduct, and improve service delivery in alignment with the national development objective and the Constitution. The bill seeks to amend Section 11 of the PAMA to create NSG as a national department, as it is currently, as opposed as being created as a higher education institutions, while still empowering the NSG to provide education and training to employees in all spheres of government, including municipalities. A clause is inserted to ensure that the NSG will provide compulsory education and training, and the cost therefore must be borne by the individual's department. The provision is made for the NSG to provide programs and courses and to issue qualifications, part of qualifications, subject to the NQF Act 2018. During the portfolio committee, the NSG requested the committee to include specific provisions to enable NSG to conduct assessment in respect of education and training. The bill was amended accordingly. Their also concern was clause number 14, removal of disparities in the public administration, Section 17A, and new provisions. The comment is needs simple salary scales across all institutions. Salary disparity are evident, either public institution versus the department. Our response is Section 17A seeks to address the removal of unjustifiable disparities across the public administration, including public entities. Section 17A is limited to employees who do not fall within the scope of the bargaining council. Further, Section 17A seeks to address unjustifiable disparities by providing a process for the minister to, after consultation with the relevant minister responsible, prescribe norms and standards to establish the upper limits of remunerations and conditions of service for employees who do not fall within the scope of the relevant bargaining council, and steps to remove unjustifiable disparities, same among employees in and across institutions and public entities, provided that such steps must reduce the salary of employee unless provided for in an act of parliament or collective bargaining. The reflections of the changes 17A 1A was initially intended to cover all employees. However, the discussion in portfolio committee were that conditions of service of the employee within the bargaining units must be dealt with in terms of the binding arrangement. The provisions was amended accordingly. The Northern Cape concerned its clause 5, conducting business with the state, Section 8.4 new provisions. Their comment was the minister may prescribe that a certain transitions between an employee and an organ of state which are remunerative but not for profit do not constitute conducting business with an organ of state for the purpose of this section. Limits the power of the minister and provide a discretion, not binding. Our response is And an example to demonstrate the proposed new position is when a teacher mark matric exam papers and get paid therefore by the state in addition to their normal state. Therefore, the minister has the power to prescribe that a particular transactions which are remunerative but not for profit does not fall within the ambit of conducting business with the organ of state. When the bill went to the National Assembly, the word and which are necessary for the functioning of an organ of state were inserted, as they were of the opinion that the power of the minister was too broad. When the minister prescribed a transitions to be remunerative but not for profit, and which are necessary for the functioning of an organ of state, the minister must ensure public participations in the regulations making processes, as well as the consultations with the Minister of Local Government and Finance and organized local government. The Free State concerned is in clause 2, individual transfer, section 5.1. Their comment is lack of clarity regarding the potential transfer of employees. Provision must state that employees should be consulted prior to any transfer. Our response is section 5 of the PAMA stipulate the requirements for the transfers to take place. In this case, in short, is the employee will give a consent before the transfer can take place. And then clause number 3 is a secondment, section 6.2. Their comment is amend to paragraph C. In the absence of consent due to considerations of any representations by the employee, if the secondment is operational justified, the word justify needs to be defined to avoid ambiguity. Our response is operational justified based on its literal meaning will include circumstances that are necessary for the departments to function effectively and efficiently, which should be all-encompassing, whether for the economic reason or otherwise. A definition may limit the intent of the provision. Further, Free State Consent Clause 5, conducting business with the state. Comment section 8.1 should be expanded to include official and their extended family members in the prohibition of conducting business with the state. Our response is employee as defined in the proposed amendment to section 8.1 of the PAMA are prohibited from conducting business with the organ of state. PAMA is only applicable to employees as defined and does not include their extended families. Extending such prohibitions to their family members may approach sections 22 of the Constitution. Further comment is clause 6, conduct of employee or a former employee participating in award of work to service providers. Section 8A, new provision. The comment is the cooling off period should be longer than 12 months and include public entities. The comment is noted. The bill seeks to balance the constitutional right of a persons to trade on sections 22 against ensuring that they do not divert state funds to entities that they intended to ultimately benefit from. The prohibitions of 12 months was deemed reasonable to avert a constitutional challenge. Section 8.1 specifically defined employee for the purpose of this section. The definition does not include public entities, but it includes special advisors. Clause 6, conduct employee again. The minister comment, the minister may prescribe a certain transactions between an employee and organ of state, which are remunerative but not for profit, will not constitute business. This power is too broad and may enable abuse. Our response is to avoid unintended consequences. The minister is empowered to prescribe that a certain transitions between an employee and an organ of state, which are remunerative but not for profit, and which are necessary for the functioning of the state, do not constitute conducting business with an organ of state for the purpose of this reason. I think the example is for the matric markers. Therefore, the minister is empowered to prescribe a certain transitions which are remunerated but not for profit, Then it should be noted that the words "and which are necessary for the functioning of organ of state" were inserted in the proposed new clause when the bill was before the National Assembly to curtail the power of the minister to prescribe a certain transaction as being remunerative but not for profit, and which are necessary for the functioning of the state. Another concern was clause 9 for the NSG, section 11. Their comment is the capacitations of employees should not be contingent upon availability of funds, as implied in the bill. Why is the NSG becoming a national department rather than a higher education institution? Our response, I think, is still the same how we give it to Mpumalanga. And then clause number 14, removal of disparities in the public administration, section 17A, new provision. Salary disparities will likely persist due to limits on reducing current salaries without legislative or collective agreement. Our response is section 18.6 to address removal of unjustifiable disparities. I think this is the same response we gave it to Mpumalanga and Northwest. Section 17A6 to address unjustifiable disparities by providing a process for the minister after consultations. This is the same response we gave it to the previous provinces. Then another clause is 14, determinations of condition of service with financial implications to section 17B, new provision. These sections increases political interference in the public administration function. Our response, 17B manages condition of service that have financial implications on the state and provide for a coordination processes, given that all three spheres of governments, including public entities, each have their own processes when determining condition of service. The Committee of Ministers at section 17B2 only provide a mandate in the instance, and that is the only task that they can do. Then Free State 17.2A and A small a of the PSA provide for the creations of the COM for National and Provincial Department, which must give approval for concluding a collective agreement in respect of conditions of services with financial implication. The proposed section 17B3 provides that when it comes to local government and public entities, the MPSA and the Minister of Finance must be consulted before entering into collective agreement in respect of condition of service with financial implication. The said clause does not envisage political interference in the public administration function, but rather provide for a coordination mechanism when determining condition of service where financial implications is involved. The general comment from the Free State, the bill should establish an independent appeal structure for disciplinary matters rather than assigning this role solely to the executive authority. The process must ensure that all parties involved are granted a fair hearing during the appeal processes, and the executive authority must not resolve the appeal without consulting the parties involved. Our response, the bill does not propose any amendment related to disciplinary processes and management. The Code of Conduct for the Public Service Employees, Chapter 2 of the PSR 2016, and the Code of Conduct for Councillors and Staff Members in the Municipality, Local Government Municipal System Act 2000, are well established and aligned to the Labour Relations Act. And applicable collective bargaining agreements, disciplinary code of conduct and procedures as contained in the PSAB Resolution 1/2003 and the SALGA disciplinary procedure collective agreement. Provision is also made for appeal in the mentioned legal prescript. The KZN province, their concern are the following. Clause 1, definition section 1. Section 8.1 and 8.2 define employee to include a sole proprietor. Our response, The bill does not propose an amendment to definition of employee. In PAMA, it does not, however, propose the insertion of a new definition of a director, which means a director of a company as defined in Section 1 of the Companies Act. Sole properties are included in the definition of the Company Act. Their concern also is Clause 6 to conduct an employee or a former employee participating in award of work to service providers. Section 8A, new comments. Section 8A2D and Section 8A3 change the cooling off period from 12 months to 54 months. And then Section 8A7 delete the 1 million rand fine and insert imprisonment or both with the fine to be determined by the judicial officer. Include an imprisonment option in addition to a fine. Delete proposed Section 8A8. Ministers should not increase the amount of the fine from time to time. Our response, the comment is noted. The bill seeks to balance the constitutional right of a person to trade. I think this is the same response we give it to the previous one regarding the cooling months period. And then Section 8A7, the proposed Section 8A prohibits an employee from accepting employment with the service provider during the cooling off period, and also prohibits the service provider from employing that particular employee who participated in the procurement processes. Should the employee or service provider contravene Section 8A7, they will be found guilty of a criminal offense and liable to a fine not exceeding 1 million rand upon conviction. These proposed sections create a statutory offense, and judicial officer is guided by a maximum amount of the fine in determining the appropriate fine, taking into account mitigating and aggravating circumstances in the case. The policy decision was to have 1 million rand as a fine to start as a benchmark. Section 8A, the Minister of Justice and Constitutional Development can adjust the amount of a fine by publishing notices in the Government Gazette, often using Consumer Price Index for preceding 12 months to reflect the inflation. In Gauteng, their concern was clause number 5, conducting business with the state. By changing definition from state to focus on organ of state, under Section 8 of the Principal Act, the bill seeks to extend the influence of the national governments over personal matters at local governments level. This may very likely violate Sections 160 of the Constitution, which assign control over personal matters in municipalities to local accounts. Our response, the PAMA does not provide the definition of state. The inclusion of a new definition of organ of state is aligned with the definitions contained in Sections 239 of the Constitution and was inserted for purposes of clarity and easy of interpretations and includes all 3 spheres of space. The term organ of state is also defined elsewhere in the PAMA. Further, does the bill violate Section 160 of the Constitution's internal procedures? Section 161A of the Constitution provides as follows: a municipal council makes decisions concerning the exercise of all powers and the performance of all the functions of the municipality. Section 8.2 of the PAMA provides that an employee may not conduct businesses with the state or be a director of a public or private company conducting business with the state. Section 8.3 further creates an offense for anyone found guilty of contravening this provision. The bill does not materially alter the core purpose or effect of Section 8 of the PAMA. Section 8.1 remains unchanged, with only modifications being the additions of paragraph 8.1b, which provide definitions of a director and insertions of a new definition of organ of state for clarity at Section 8.2a. Section 8.2 and 8.3 also remain largely unchanged. The only substantive addition is the new subsections 8.4. In other words, the bill does not change the substance of the Act, which is that employees in public administrations might not do business with an organ of state or be directors of companies as defined in the Act of doing business with the state. Therefore, the bill does not encroach on powers and functions of municipality. However, if the member question pertains to Section 8 of the PAMA, this equally does not infringe on any municipality right to govern. Municipality rights to govern is not boundless. Section 1513 of the Constitution provides that municipalities' rights to govern on its own initiative. The local government affair of its community is subject to national and provincial legislation as provided in the Constitution. Further, Section 154 of the Constitution states that national provincial government by legislative and other means must support and strengthen the capacity of municipalities to manage their own affairs, to exercise their own power, and to perform their own functions. In terms of sections 1557 of the Constitution, national government, subject to Section 44, and the provincial government have the legislative and executive authority to see the effective performance by municipality of their function in respect of the matters listed in Schedule 4 and 5, by regulating the exercise by municipality of the executive authority referred to in the above section. National government may provide for minimum standard and framework to enable municipality functioning. The Constitutional Court has held that national or provincial government cannot intervene in the function of the municipality. However, Section 8 of the PAMA does not usurp the power of municipality to exercise its original legislative power. It merely provides a standard that all employees of the public administration should not do business with the state in order to safeguard or prevent corruption. Again, is clause number 5, conducting business with the state. It is proposed that the national database of transgressors should be developed and published for quick tracking and identifications across all provinces in order to discourage corruption. Our response, the Municipal System Act, and specifically Section 57A, employment of dismissed staff and record of disciplinary proceeding, mandates that municipalities maintain a record of disciplinary proceedings for staff members dismissed for misconduct, including those who resigned before the finalizations of the proceeding. This record must contain a certain prescribed information and must be submitted to the relevant MEC for local government on a quarterly basis. In terms of Section 16(1)(g) of the PAMA, the MPSA has the authority to prescribe norms and standards regarding the disclosure of information pending disciplinary action and concluding disciplinary proceedings where the employee was found guilty. Furthermore, they are saying to ensure the proper implementation Section 16(1)(g)(p) of the PAMA, the DPSA drafted the Public Administration Management Regulations for the Central Register 2024, which was already published for public comment on 24 January 2024. The final draft of the regulation has been referred to the Office of the Chief State Law Advisor for an option. The purpose of the draft regulation is to create a central register that will be utilized by the institution for disclosing information relating to former employees in the public administration who have been dismissed on ground of misconduct, resigned after disciplinary proceedings were instituted, or being charged with misconduct but resigned before the disciplinary process were concluded. The draft regulations aim to enhance state integrity, strengthen the capacity for vetting new and existing employees, and implement the preventative measures against corruption and maladministration. directly responding to the state capture recommendations by creating a unified system across all government spheres. The information in such database will be governed by the Protection of Information Act and the Promotions of Access to Information. Also, clause 6, conduct an employee or former employee participating in an award of work to service providers, section 8A. 12 months period mentioned in section 8A and 2D be amended as follows. Delete 12 months period and insert 36 months period. The response is still the same how we responded to other provinces. Now, coming to the Eastern Cape, their comments are as follows. General comment, the issue raised by stakeholders relating to the bill should be given considerations by the department when formulating the regulations. Our response, once the PAMA Act is promulgated, the DPSA will duly consider the issue raised when drafting the regulation. Further comments, view raised that upon transfer of employees, condition of service must be protected. Request that 12 months cooling off period for employees participating in an award of work to service providers be longer than 12 months. Our response is still the same how we responded with others. Then there is the Western Cape. Do you still want to do Western Cape and Western Government? Chairperson?
With the Western Cape, we dealt in detail with both bills in the previous meeting. Let's keep the province.
Okay.
We spend more than 2 hours dealing with those.
So the Limpopo legislature voted in favor with the bill with recommendations. However, recommendations were not indicated in the negotiation mandate. This is the end of my presentation, Chairperson.
Thank you very much, Robert. Let's us invite legal to summarize.
Okay.
Thank you, Chairperson. Thank you, Chairperson.
Yes, you can proceed.
Thank you, Chairperson. For the sake of brevity, as is custom, Chairperson, when dealing with negotiating mandates, usually we summarize these in the form of a matrix. The matrix provides members with an overview of what each provincial legislature has voted on, the date of the deliberation, the comments raised by each provincial legislature, and the responses thereto. The matrix was circulated to members prior to this meeting, Chairperson and members, and I trust that they have familiarized themselves with the contents thereof. Therefore, we will not go into the detail of each negotiating mandate. But what is important to note, Chairperson, that of the 9 negotiating mandates, 2 negotiating mandates were not in favor of the bill. Those provinces were KwaZulu-Natal and the Western Cape Provincial Government. Of the 7 provincial mandates that were received, only 6 provided input. That was the Free State, Mpumalanga, Northern Cape, Northwest, Gauteng, and the Eastern Cape. Limpopo was in favor of the bill, however, they did not provide inputs. We have considered all the queries from all 9 provincial legislatures, Chairperson. We have responded thereto, and in essence, the response is as collectively agreed with the department that there should be no further amendments made to the bill, that the bill should be adopted as is, that all legal questions, drafting issues, policy issues have been addressed by the department and the Constitutional Legal Services Office, and that we would like to offer members an opportunity that should they need further clarity on the negotiating mandates and on the matrix that's in front of them that is being flighted as we speak, that we can offer that clarity now in this meeting. However, if there are no further questions, Chairperson, if you'd like me to assist the committee, I can flight each negotiating mandate. Thank you.
Let's do so. You can flight the provincial mandate.
Okay, we have the Eastern Cape.
Sorry, Chair.
Who's that?
It's Panyaceza.
Oh, Honorable Kaza.
No, I'm sorry, Chair. I thought before you go to the negotiating mandates, you'll then give us a chance to raise some few concerns, which is things that we perhaps what we were doing before the public service amendment. So I thought that you would bring that up again, because now what is concerning is that the department has not responded to my previous question there, because the context of my question is that, having considered all the concerns of the department of the provinces that did not support this the previous bill and this one, how does the department and Parliamentary Legal Service anticipate tabling proposed amendments in both bills in line with the amendment proposed by different legislatures? Because we must not, we are here for 5 years, you know. We must not be seen to be rushing towards the goalpost and listening to a department that is just telling us that commas and dots and full stops. I hear some genuine concerns from the department, departments, the provinces like KZN, for instance, and the Western Cape and Free State, even Limpopo, who is in favor, has got some concerns, and they say that the concerns have not been sourced, and I don't understand how I'm going to consider a recommendation or a concern of the whole province and its people and its population and its position on the bill, and then how are you going to respond to it if you have not been able to receive it in the first place? So it's quite concerning that when we deal with these things, because I said that previously, let's look at the focus on details. And then we picked up that there is an issue on the Northern Cape where there's a typo error on the part of the bill, the number of the bill. And such things can really take us to task as a select committee, having to just be concerned with kicking the goalpost or fast-tracking bills as part of being concerned, or perhaps being trying to do right, but acting left. You know what I mean? So I do not understand how the department just overlooks an issue of concern of the province, because sitting here, it's easy to just say province A and B, you know, but you must consider that behind that province, there is livelihoods, there's people there that will be affected. There is workers, and then there is an issue of disparities, which actually is actually at conditions of employment that has to deal with salaries, issues, and employees, which will ultimately impact on the livelihoods, and then impact on the employees. So the department must just respond how they will consider those, or they have considered those concerns in terms of it doesn't matter, they do not form a majority of the voters, because we are not here.
I think, Honorable Treza, we have captured your concern.
We are not here.
Honorable Treza, Honorable
We are
Treza,
here to fix
Honorable
legislation.
Treza,
Legislation requires us
Honorable
to focus
Treza,
on detail.
Honorable Treza,
I hear you,
yes,
sir.
we have captured your concerns, but we can't allow you to continue with the statement because time is against us. But I think what department have done with both the inputs of the legal unit of the NCOP as well as the department, they have responded to each and every issue raised. But it is not given that when you submit, your submissions will then be inserted to the Act. When you submit, you make your views, and after having made your own views, then the department has to respond whether in accordance with the legislation or constitution that can be captured. If not, those responses, the point that you are raising, which is important, is that all those who have made submissions, provinces, individuals, organizations, should be responded to. And no organization or any entity that must not receive a response on what they've submitted, including provinces, so that they will understand that how come their views were not inserted, but they were acknowledged. In some instances, there were points which were made by the department that they note those comments for processing. Some of them will find expression during the regulations in terms of implementation of a particular act. So let us just hold it that way, because it can't be 100% that every submission will be captured when the finalization of the bill is made. But those concerns were noted. Some were dismissed on the basis of what the law says, and in terms of with the intention of protecting the institutions to ascertain that you don't go with a recommendation which contradicts the constitution or the other act that is also operational. So let's just hold it that way. We'll request the department just to zoom to provinces and allow you as delegates to make pronunciation as we did in the first bill. But all the corrections, you are correct. Whatever that is captured incorrectly, they must go and clean the document. That is why legal said there are corrections that they are going to effect, which they've identified, and some which were raised by provinces. So those must be effected before we go for the final approval of the bill. I'm hoping that I'm covering you, Honorable
Chairperson, Chairperson,
yes.
if I may. Sorry, it's Talana from Parliamentary Legal again. Chairperson,
yes,
with
sir.
regards to the PAMA, it's a bit different from the PSA chairperson. The PAMA only created one typographical error, and that will be corrected when we handle the proofs. And Honourable Treza is correct. There were comments from KwaZulu-Natal, as you can see what's flighted on your screen, when they were not in favour of the bill. And we have addressed all those comments. We did not address them. We considered them. So did the department. We responded to them sufficiently, and based on those responses, we are now not proposing that the bill be amended, because we feel that we have responded to Western Cape and KwaZulu-Natal's issues with the bill, and we hope that in the responses, that when the provincial legislatures reconsider their mandates and provide their final mandates, that our responses will be sufficient. So Honourable Treza can take our responses back to the provincial legislature and then see if those address the issues that are raised in the province, and that will feed into the final mandate. I hope I'm clear, Chairperson.
Thank you. The point I was also making is that all those who made submissions, whether individually or organization, entities, legislatures, they must be responded to through their addresses on the specific issues that they've raised, so that tomorrow they won't be accusing the legislature, that the NCOP and Parliament, that they were not responded to, but we have approved the bill. So that's a finest detail that we need to persist with, to ascertain that all those who made submissions in writing, they've been responded to. So that will close the gap, so that when people are saying we made submissions but no responses were received, evidence can be produced. Thank you very much. Let's move to the mandates of provinces.
Chairperson, I see that the department has their hand up.
Yes, you can come in.
Thank you, Chair. I just want to add on to what Talana has said. I think because we also, in developing the matrix in the presentation that is before the select committee today, we have confirmed also with regard, especially with the Limpopo one, whether there are any issues to be addressed. We looked at the report, the minutes, and we've looked at each and every mandate that we've received with the reports, and addressed all the issues. So we are both the parliamentary legal advisor, Talana, and ourselves, the department, on par on what responses we have given on our matrix and presentation. Thank you.
Thank you. Let's deal with provincial mandates.
This is Eastern Cape, Chairperson.
Eastern Cape, Honorable Peter.
Eastern Cape is in support, Chair.
Thank you very much. Next province.
The Free State, Chairperson.
Honorable Dr. Skir Kocher. Honorable Skir Kocher, are you still there? But you can all see on the records, Free State is in favor. Next province.
This is Gauteng, Chairperson.
Honorable Nzimande.
Gauteng Provincial Legislature supports the public administration amendment or management bill, subject to the consideration by the selection committee or select committee of the following as contained in the document. Sure. Hey.
Thank you very much, Honorable Nzimande. Next province.
Hey. Sure.
KwaZulu-Natal.
KwaZulu-Natal is not in support. Next province.
Limpopo.
Limpopo, Honorable Molokome.
Limpopo.
We lost you, Honorable Molokome.
Limpopo votes in favor of the bill.
Thank you very much. We lost you because of network. Next province.
Mpumalanga.
Mpumalanga. Honorable Kaiser.
Thank you very much. The name of the bill, Public Administration Management Amendment Bill. Number of the bill, B10B 2023. Date of deliberation, 12 May 2025. Vote of the legislature, the oversight committee of the legislature and the premier's office, after considering the Public Administration Management Amendment Bill, confers on the permanent delegate or representing Mpumalanga province in the NCOP a mandate to negotiate in favor of the bill without any proposed amendments. Thank you.
Thank you. Next province.
Northern Cape. Northwest.
Cape.
Northwest.
Oh,
Sorry,
Northwest.
Chairperson, Northwest.
Honorable Mabibo. Honorable Mabibo, are you there? It is clear the province is in support of the bill. Let's move to the next province.
Northern Cape.
Northern Cape.
Thank you, Honorable Chairperson. The Honorable Zimbabwe disrupted
Honorable
me, Chair.
Zimande, can you mute? Honorable Zimande, can you mute your mic? Honorable Zimande, can you mute your mic? Honorable Zimande. Honorable Zimande. Honorable Zimande.
Chair, ask the administration to mute him.
Can you mute him, please? So this is about the MK party.
Thank you.
Okay. Honorable Mangu can proceed.
Thank you, Chairperson. Chairperson,
Okay.
The select committee convening on the 8th of May voted in favor of the bill, Chair. Thank you.
Thank you very much. Next province.
The last province is Western Cape.
Thank you, Honourable Chair. They normally leave the best for last. Honourable Chair, Public Administration Management Amendment Bill, Bill 10B of 2023. Date of deliberation was the 18th of June 2025. Standing Committee on Premier and Constitutional Matters, having considered the subject of the bill, referred to it in accordance with Standing Rule 217, confers on the Western Cape's delegation in the NCOP the authority to not support the bill in its current form and proposes amendments as reflected in the report. The committee will reassess its position on the bill during the final mandate stage, contingent on whether the proposed amendments are considered. Thank you, Chair. I so submit.
Thank you very much, Honorable Host. Mr. Manele, can we get the final results?
Thank you, Chairperson. Chairperson, only 2 provinces, permanent delegates were given powers not to support the bill. That is KZN and Western Cape. The rest, Chair, conferred with powers to support the bill, Chair. Thank you.
Thank you very much. That's an outcome of the mandates from all provinces, 9 provinces. 7 are in support, 2 are not in support. Please, let's accept that as a majority rule. Then let's thank the department and our legal unit for having done their job well to respond to all issues and give legal advices. That is highly appreciated. Now, this has brought us to an end of this session. We'll request members to remain for 2 minutes to deal with minutes. Then we adjourn the meeting. Thank you very, very much. The first session with the department and legal unit, it's now over. We are moving to the internal processing of matters, minutes of the committee. Members, the minutes were deposited to you on time. Can we get a move if there are corrections on minutes? Are there any corrections? If not, can we get a mover and a seconder?
I will move, Chair.
Honorable Chair, second. The minutes are duly adopted. Thank you, members, for your time. And we know we have gone through your own lunch time. Sorry for that. And lunch is already organized for you. You just produce your card and have your lunch. The meeting is adjourned. Thank you to our team, support team, for the work. The meeting is adjourned. Thank you very much.
Yes.